Friends, many amendments and clarifications white circulars have been issued in the matter of GST refunds. We would try to discuss all of those recent amendments and circulars in this video. The first amendment in the recent past was Wide Union Budget 2021, where we all know that on payment of duty refunds have been done away with and would be invoked from the day on which Section 16 of the IGST Act as amendment is notified. So, from now, exporters should try to file their refund wide LUT mechanism and they should do exports without payment of duty so that the process is streamlined. Along with that, the foreign exchange or the money related to the export has to be received within 9 months or 12 months as allowed by the RBI. If that is not done, then the refund amount under GST has to be returned back to the government with interest. The same was already notified by Rule 96 capital B of the CGST rule. Now, wide amendment under Section 16 of IGST Act, the same has got more teeth and legal backup. Now, after this budget, circulars 4 and 5 under customs were issued for relaxations. So, the government has done a nice balancing act. Wide Circular 4 2021 dated February 2021, the time period for filing of mismatches between the GST refund amount and the tax paid amount in GSTR 3B table number 3 for export of services has been extended for the period 1920 till 31st of March 2021 and for the period 2020-21 till 31st of August 21. So, there were many errors whereby export or zero rated supply of services were disclosed under table 3.1.A instead of 3.1.B. Circulars were issued earlier whereby the mismatches due to such errors were taken care of till 31st of March 2019. Now, till 31st of March 2021 for the financial year 1920, in case you have such a GST refund stuck up, the same can be filed for 1920, and for 2020-21, in case you have such a refund which is stuck up, you can file for the refund till 31st of October 2021. Similarly, Circular 521 again dated February 21 was issued whereby SB 005 errors can be rectified now on a permanent basis till 31st of March 2021. There would be an officer permanently stationed in your jurisdiction customs office to which you can pay a fee of rupees 1000 Wide Circular 521, and in case you have an SB 005 error, you file the concordance table and you can get it rectified. So, this is a welcome relaxation as per Circular 5 2021, and in case you have such a case which is pending, the same can be resolved down. Friends, another major clarification was Wide Circular 147, which was issued on 12th March in the evening, that is yesterday. Incidentally, I was amidst a lecture and one of my colleagues in Bill GST, he informed that such a circular had come and I was discussing the same point. Now this clarification vide para 4 of circular 147 has clarified a major point and not clarified I would say error in drafting. So in March 2020, it was notified under Rule 89, Sub Rule 4, Clause C was amended and notified. Now, what was this Clause C? We all know that refunds without payment of duty is sanctioned with the help of a formula. What is this formula? It is very simple. Zero rated supply of goods or services in the numerator divided by adjusted total turnover in the denominator into net input tax credit. Well, why this clause C of 89.4? It was notified that for the purpose of this formula, zero rated supply of goods would be restricted in value to the amount of 1.5 times the value of domestic supply by the same or similarly placed supplier. Well, there were two confusions. That okay, if I supply goods domestically of value, I am using the word value, mind that. So if I supply goods of value 1 lakh rupees domestically, I would be debarred from supplying more than 1.5 lakhs in value for exports under GST. Well, that is not the intention of the notification. In the circular also, there is an illustration which has restricted the amount of export in the numerator by value per unit. Mind that there is a difference. The total export value would not be restricted. It is not that if you don't supply anything domestically, if your domestic supply is 0, you get 1.5 times of 0, that is 0. So you get no refunds. No, that is not the intention of the notification, not the intention of the circular. However, the restriction of 1.5 times is on value per unit. That is, in case the value per unit of the goods which are exported is more than 1.5 times the value per unit of the goods domestically supplied, then the value per unit of the export would be restricted to 1.5 times. So, if your domestic supply value per unit is 200, the value per unit would be restricted to 300 rupees and you cannot supply at a rate more than 300 rupees in the export market. Okay, at least even if you supply, your refunds would be restricted to 300 rupees. That has been clarified. In fact, not clarified, I would say, why did circular. But if you see the illustration as in your screen, it would make it very, very clear. The second, which is a welcome clarification, is that, well, if the value of export per unit is restricted in the numerator for the purpose of adjusted total turnover in the denominator, would the value of export be restricted to 1.5 times? Well, the logical answer is yes, otherwise the whole formula would be vitiated, and it is rightly clarified by the circular, giving legal examples and giving legal definitions as per GST law. So now two things are very clear as per this circular 149 with respect to rule 89.4. Number one, the adjusted total turnover would include and restrict the value of per unit of export to 1.5 times of the domestic supply value of same or like supplier 1, and this value of export which is mentioned in the rule is not actual value but value per unit of the quantity which is exported. There are other two clarifications vide this circular. First is regarding deemed supply. As we all know, in case of deemed supply, the recipient or the supplier can claim the refunds under GST. Therefore, in case the supplier claims the refund, he has to give a declaration or get a declaration from the recipient that the recipient has not claimed the refund. Similarly, if the recipient claims the refund, then it has to give a declaration or get a declaration from the supplier that the supplier has not claimed a refund. To this extent, it is great. However, the question was that as per circular 125, there was a small error wherein it was stated that the recipient, if he claims the refund on deemed export, it would not be able to even avail the input tax credit on such deemed supply. Well, it led to a double whammy, whereby on the one hand, the recipient was not allowed to claim the input tax credit, and on the other hand, while claiming the refund, the amount of the refund was debited to the input tax credit ledger. Now, this circular 125 to this extent has been amended, and now it is clarified that as per third provision to rule 89.3, absolutely the recipient is within its right to avail the input tax credit. Friends, one last clarification and a relaxation I would say is that there were many cases whereby the refunds were stuck up because the value in the GSTR 3B was not matching, or the value in GSTR 3B as per table 3.1.a was less than that declared in GSTR 1. Then you had to go and give an explanation to the GST officer, and thereafter your refunds were sanctioned. This relaxation has been further extended till 31st of March 2021. So now till date you can go and get the same error if any rectified. So friends, these are the various relaxations, amendments or clarifications under GST refunds which we must all take note of. The PPT could be shared with you as appended in this video also. Kindly do mail us at the mail ID which you see in the appended PPT, and we would send the PPT to you. Our articles are also available online in various social media websites. In regard to all of these amendments, you can always get hold of this, and the entire issues we have tried to make it clear. Thank you very much.